So right now, Svitlana is located in Istanbul and exactly cooperating and supporting the international session of negotiations. And even though we have not so much time, but today's topic is a very broad one, and this is some kind of a challenge to give it in a short session. So why exactly me, and why am I capable of speaking on this topic? I am in the sphere of mediation for more than 10 years, and my expertise and mediation in the sphere of businesses, of different businesses, of different audiences, mediation with international bodies. I'm also a permanent expert of international bodies like WIPO, World Intellectual Property Organization, United Nations, USAID, and so on. So let's start. Prior to talking about what mediation actually is and what type of instrument it is, I'm always speaking about like what the mediation is working with. And mediation always works with different types of conflicts, with different types of disputes. And today we'll be discussing directly this type of disputes or conflicts which arise in the online collaborations. My point of view, this type of conflicts I'm sorry for a small technical pause. These are different types of conflicts which occur on interpersonal level with different structures, with the co-authors, with the contractor and the creator. Conflicts when the subjects which engaged in the projects have a transnational entity. And when we talk about the online collaborations, here we'll also have the focus, I'm sure you have already heard about it, as intellectual property. This is one of the issues or the moments which are crucial and one of the most complicated ones for the mediation, not only from the part of resolving the conflicts, but also when the conflict is getting resolved, not during the negotiations, but also when some legal parts occur and litigation begins. What types of disputes actually arise? They are mostly connected to any type of providing the contractual obligations. Also, as a part of planning the future collaboration. And here we speak about that prior to actually creating and drafting a contract about the collaboration, you have to negotiate and to have to discuss the basis for it. And we call it a partner planning of the further relationships. Second type is the type of conflict which occur out of the contractual part. The ones which are not in line with the written documents. In mediation, we always have two dimensions of conflicts. One is in the part of processual relationships, and second is exactly in the interpersonal relations. All the conflicts about the relationships. So what are the specifics of the online collaboration conflicts? course, here we have both types of interpersonal relations, the conflicts where we have the conflict of interests, of values, and of course, the processual ones. How, what, and where we can do and what can be done step by step. Conflicts about how we both as different parties see the process of actually providing the final results. These are always the aspects which we take into account as the first ones. This is a type of conflict where we already go to the lawyers or other legal representatives. We talk about the processual relations. And this is also a type of relations which influence interpersonal relations as well. And in this case, we're speaking about the alternative methods to resolve the conflicts. Why exactly the alternative ones? So how to help to resolve the conflicts? Exactly as an alternative method to going to the court. Because maybe in your case, the legal system was not taken conflicts in a full scale, or was not taken into account type of conflict which are also going in depth of the sphere you're working with. And all of these methods were united into what is called alternative methods. But as of today, I can say that in general, the international community goes beyond the formulation of alternative methods, because the majority of the methods which I will be discussing now are not already actually called as an alternative or a directly opposite solution in comparison to the legal system, but as assistant ones to the legal system. So now the term of effective solutions of the disputes or conflicts is mostly used. So what are the types of solving the conflicts or disputes? They can be unified in 4 directions. First one is a clear or the main procedures. Here's also some mediation slang. This is exactly the negotiation, the representatives, the arbitrage, and also combined ones. So this is a mix of different procedures. So mostly having representatives and arbitrage, and as well as negotiations. And now there are more than 15 combined procedures. Which are used in the sphere of creative industries to resolve the conflicts. And in general, they are called as in court and out of the court. So what are the main ways and the main features of resolving the conflict in the sphere? So when we talk about online collaboration, we intuitively start to use different type of negotiations. But is it actually a negotiation or not? That's a good question. So as to have it and to call it as negotiation, it should be a procedure where you discuss a problematic question or issue, or when you plan any type of activities, where you have two or more sides with an idea to create this type of negotiation where you do it horizontally. So one person with another person, and you have the mutual interest in creating a project. That's where the mediation steps in. Mediation is exactly a type of negotiation when you have not just one person and the other person who are talking to each other, but also a third party, a neutral party, a representative, who helps to create a communication so that both sides will come up with a mutual solution or resolution to dispute or conflict. But this middleman, this third party, does not actually come with a decision regarding the issue. And third type is exactly an arbitrage, is already a legal procedure. This is exactly a type of resolving the conflict. By a person or a group of persons who are selected by a group of the sides. And the sides give the rights, give the authority to the third party to decide about the legal forms of resolving this conflict. So if we discuss negotiation, representativeness, and arbitrage, negotiations is mostly unregulated type of resolving the conflict. With representatives, we already have a type of procedure which in one way or another should be complied with. And arbitrage, which is already obligatory for the sides to comply with the solution which was taken by the arbitrage. So what can be taken into account while choosing the type of procedure to resolve any type of dispute or conflict which you can have in the online collaboration? So first thing which we ask in mediation, or what will help you? What will be more costly for you and less effective, to go to the court or to resolve a procedure without going to the court? And we call it a price of entering to the conflict or a price of resolving the conflict. And there is always a question which I pose when I'm doing a mediation. How much is your conflict worth? How much will cost you the situation if the conflict is not resolved? And if you will not come to a mutual decision, what will be the outcomes? Or how much it will cost you if, when you were just discussing the future collaboration, planning it, about your mutual activities, you have not discussed what will happen if you will not be able to compromise and agree on something when you have the disputes. So what should be in the focus for you, and how to actually calculate the so-called price of the conflict, because it's usually not about money. The price is what we can lose if we will not come to a mutual decision. So first of all, it's of course good relationship between each other. Secondly, these are the additional opportunities or the additional good which we can mutually create during our collaboration. That's exactly what type of influence can we do as a result of our online collaboration. Or what can be not done if we will not come to a decision. And that's how we calculate the so-called price of the conflict. Exactly taking into account the perspective of the relations. And what will be the outcome of our negotiations. Or what type of negative context can come up if we will not come to a mutual decision. And usually when the sides are in the conflict, this conflict gets out of these two sides and starts to influence your families, your closest circle. And these conflicts get not just interpersonal between the both sides of the collaboration, but also have a wider and more broader influence. Also on your partners from other collaborations. And when we talk about the collaborations where we have more than two sides, we can say that we will have a different expenditures of what will be lost if we lose some of our contractors or partners. This is also a loss of a potential good impact of our collaboration or the revenue which we can get. So if I'm in the conflict, I'm of course not in the resource state. I cannot product a new creative ideas. And therefore, when we decide what type of method to be used when we work with our conflict, we evaluate the so-called price of the conflict with the aforementioned points. So what is next? When we have evaluated the negative sides of the conflict which we have, we can also evaluate the outcomes if we will not resolve the conflict and how much it will actually cost me. So if you and me will not come into decision right now, what will be in a week, in a month, when this conflict gets bigger, when it's growing? And what will be the result if we will be in the conflict? Or what we can get if we will start this negotiation procedures. And my personal point of view, one of the most effective ways to resolve the conflict is exactly a procedure of mediation. So what is mediation? Mediation is a flexible process of negotiation, which is fully confidential. So nowhere in the public sphere you will not see that there was conducted procedure of mediation. And if you know how the how the litigation is taken, some of the processes in court are public. And in mediation, the processes are fully confidential, where the third party, a neutral party, helps the sides during the process of negotiation to reach a mutual decision about resolving the conflict. But that's important, that the sides, the parties, they decide by themselves how to resolve the conflict. So the key point here is flexibility of the process. Some of the conflicts can be resolved in 4 hours, in 6 hours when we work as mediators. And if we compare it to the legal procedures, of course, in some cases, they can be a minimum of a year. Second key point is the confidentiality of the process. And third one is the neutrality of the third party, which is getting connected to your conflict. This third party does not have any conflict of interest. This person has a special preparation, a special education to be a mediator. And the most important part here is that the sides are working together on how to resolve the conflict instead of getting it kind of forced by a mediator. And if we start with the mediation, how it can help at the process of planning your collaboration. Mediation helps to highlight the future possible conflict spheres which can occur in your partnership, in your collaboration. We work out way in advance for the future, those type of conflicts which can occur. Why do we need it? So as to foresee and get ready for the future conflicts, because we already create some kind of a procedure how we will be working on a certain type of conflict. And we already agree, even before entering into the partnership or collaboration, how we will be resolving a certain type of conflict. And of course, most usual, the sides decide that it will be in the way of negotiations or by taking a mediation procedure. Of course, mediation has some main principles, which are the key ones. First one is the free will. Any of the sides can be forced to take part into the mediation. Any side can be inactive in the process of mediation, because mediation is exactly about the case when every part of the conflict or the planning of the partnership takes responsibility on how we will be working together in the future. Also, a principle of confidentiality, flexibility. In mediation, we say that we have 4 classical stages. How's mediation is going? And it's way more flexible than arbitrage or the legal procedure, because in the litigation, we cannot get retroactive and go into the other side of the process. We go on vertical from upside down. And in the mediation, we can take the process or solve just a part of the conflict, some questions, some issues on one day. And for some other ones, we will get, for instance, the next day or the next meeting. What's also important to know when you are choosing a mediator, it should be always a neutral party, the ones which cannot be influenced. Or that a mediator, maybe not the best role to choose, will lobby or force any type of decision. So the mediator should be chosen by both sides. Mediator should be in the public registers of the organizations. So who is this mediator? Mediator is a specially prepared middleman who helps the sides of the conflict or dispute to regulate it, to resolve it by providing an organization and the structure to the negotiations. So the sphere of responsibility for mediator lies in the correct, in the appropriate way to structure the mediation. That's exactly a process and not what the person will agree on. And if you would like to go through the education about how to be better in mediation, you should know the competences, so the spheres where the mediator should be competent. And I feel that these spheres are universal to all the people to kind of raise the quality of your life. First one is the competency in conflictology and in communications. Mediator knows how what is the structure of the conflict, when you can get into it and when not. Mediator knows how the effective communication should be structured and helps the sides to communicate in the way of getting a win-win situation. Mediation has also a procedural competency. So ideally, they should know how it is possible to work out the procedure of mediation in that way that the parties can come into a decision. The separate ones goes a negotiational competency, because the classical mediation is based on Harvard model of negotiations. And exactly this Harvard model of negotiations is, in my personal point of view, the most effective ones to build an effective and long-term partnership with the other party, and an ecological type of negotiations, in my point of view. Of course, this is the legal knowledge. The mediator should know how to draft an agreement so that the parties can still be in the legal field. Or how the agreement reached during the mediation can be also implemented by the parties or not. And of course, a reflexive side. The mediator should be very aware about the personal state of mind. Are they neutral about the procedure? Do they feel okay when they are leading this procedure or not? And that's what, in my point of view, every person needs to have if they want to resolve the conflicts effectively. What are the benefits of mediation for the procedures of resolving the issues or disputes in the online collaborations? That's an opportunity to work out a fair for every side based on the interest of each side. Because for this type of solution, every party kind of builds up what they would like to get as a part of the solution. Secondly, that's an opportunity to create a non-standard and creative decisions. Go beyond classical ways to resolve the conflicts. To have a kind of middle solutions. And one of the biggest benefits is, of course, the economy of resources and time. As we discussed, we can always count how much the conflict will cost us and how much it will cost us if we solve it with a mediation. How much time will be spent? In the classical mediations, the conflicts are resolved from 3 to 6 hours to a week. While the legal procedures are, of course, a way longer procedure. No publicity is also a benefit in some cases. In online collaborations, that's one a big plus. When the parties do not want that their reputation will be stained. Or used in any way or highlighted in any unbeneficial way in the public sphere. So the closed nature of the mediation and negotiation is a big plus. The neutrality of the mediation is also a benefit, because the mediation works with a focus on the future and putting at the first place how to keep the good relations between the sides. And the parties control how the way of creating a solution will be created. And a higher level of complying with the reached agreements. For instance, the percentage of complying with the agreements made during the mediations is approximately 80 to 85%, exactly because the parties have created it with the help of a mediator by themselves. But of course, the mediation does not cure from every type of the conflict, and there are the moments So what are the minuses? So if the parties are seeking a faster way to resolve the conflict, and this type of case was already in the legal practice, or when you need an immediate when you have to forbid something immediately and it can be done only by going to the court. The other factor or when the mediation cannot be used is when we see that one of the sides has a specific interest in this is trying to kind of prolong the process instead of resolving the conflict. Or when a side wants to have a scandal to make the situation very public instead of resolving it in the most peaceful way. And of course, when a big emotional level was reached in the conflict and the mediation is of course then not used or not beneficial to be used. And the last factor is that I'm seeing that very often in the online partnerships and collaborations is when the copyright is infringed by an unknown party. So of course, who is the other side of the conflict to be taken into mediation when we do not know this party? And of course, I could have been speaking to you about the procedures of mediation for a longer and longer time, but I see that our session is coming to, our presentation part of the session is coming to an end. And would you like to move to the Q&A session? Maybe you have some questions which you would like to address, or some factors which you would like me to cover in a broader way.